Hello friends, I am B.N. Agarwal, ex-Chief General Manager Finance, Steel Authority of India Limited, SAIL Bhilai Steel Plant. I am also Secretary SAIL BSP Pensioners Association. I am back on the same very issue, that is pension on higher wages. Before developing a video on the concerned and relevant topic, I was I was thinking myself whether I am in a society which is governed by the rule of law or the one driven by personal ego of the executives of the government. Lot of vibrations taking place across the country on various issues being raised by learned advocates of EPFO in different high courts. We are also aware that more than 3 years time has elapsed since a landmark judgment of Honorable Supreme Court in Sunil Kumar's case, and I made an analysis that due to demand letter to be issued by EPFO, almost per day not less than 600 and up to 1300 rupees we are losing in the form of interest to be paid on the differential contribution, and thereby it is almost 18,000 rupees to 40,000 rupees per month at this age when we all are senior citizens. you know uh, number of arguments have been made by advocates on behalf of EPFO in various high courts, mainly on trust rules and statutory rules. They have also painted a picture of larger provident fund over larger pension fund. They have also tried to convince the courts on options and deemed options as if it has been raised, it has been opted by the members and the pensioners. They have also tried to put long story of old story of financial deficit. They have never talked about classification, artificial classification between exempted and unexempted establishments. They have further gone by sub-classification between exempted and another exempted organizations. They have also tried to, you know, convince the court as if poor members are subsidizing the rich members. I don't know, after demitting the office, who members are poor and others who are rich, totally disregarding the judgment delivered by the Honorable Apex Court both in the year 2016 in R.C. Gupta judgment and in the year 2022 in Sunil Kumar's judgment. They have never talked about role of the employers in EPS 95. They have never talked about various conditions applicable to exempted trust for grant of exemption. In parliament queries, they have, I don't know which kind of theory they are propagating, that is defined contribution versus defined benefits. Lies after lies by EPFO. In today's video, though so many issues are to be addressed, my friends across the country, they are trying on this topic by reaching to all of us through various communications, videos, and social media. We, the association in Bhilai, Chhattisgarh, we have tried to reach at all levels in the country by way of written representations, personal discussions, and other modes also. Now, I am reminded of one key judgment of D.S. Nakara in 1983. It is more than 40 years from now, wherein it has been held by the Constitution bench of the Honorable Supreme Court that pension is not a bounty or a favor or a charity, and it does not depend on the employer's goodwill. Instead, it is a rightful payment for the services already rendered by the employee in the past. The court also emphasized that a pension is a retirement benefit that aligns with and promotes the goals of the Constitution, and it stabilizes a legal right for the pensioner. What best can be said other than this judgment? And in the background of this judgment, we all know that as if we are exempted from pension scheme, as if the provident fund scheme takes over the pension scheme. This kind of colors are being painted on a bigger canvas in the court. We all know that exemption has been given to the exempted trust, to the exempted establishments at different point in time under section 17(1)(a) of EPF Act, wherein the exemption certificate itself, it is written that rates of contribution and other benefits are not less favorable than those specified in EPF Act and schemes thereunder. Obviously, any beneficial scheme of Government of India has to be for the employees, particularly for the days when they need this type of help from Government of India. We all know prior to EPS 95, it was family pension scheme. EPS 95 was introduced under section 6(a) of EPF Act, which is mandatory to all the employees who were on the roll as on 16/11/1995 and joined thereafter. I will travel through some of the relevant provisions also. Section 6(a)(2)(b) of the Act mandates that employers of the exempted establishments shall pay to the pension fund such sums as per section 17(6) of the EPF Act. See, it is the duty of the employer to pay such sum which has been specified in pension scheme. Though they are talking about section 17(6) of the Act, I will come to section 17(6) of the Act, which says employers shall pay to the pension fund such portions of the employer's contribution within such time and in such manner as specified in pension scheme. Obviously, pension scheme EPS 95 is the child of EPF Act in a way. So all the governing provisions in EPS 95 are the key provisions as approved and passed by the Parliament of the country. Now we all know that EPS 95 scheme applicable to both exempted and unexempted establishments and organizations across the country, which is effective from 16/11/1995 under the notification number 748 dated 16/11/1995. I will read through important provisions also so as to make it clear. EPS 95 is a vast scheme. A specific para 3, subpara 2 and proviso thereof prescribes a restrictive condition for contribution to pension fund on a ceiling wages as decided by Government of India from time to time, Initially as it was rupees 5,000, then subsequently 6,500, and then now 15,000. Why this proviso being discussed now? A purpose. In proviso it is written that provided that where the pay of the member exceeds rupees 6,500 per month, the contribution payable by the employer be limited to the amount payable on his pay of rupees 6,500 only. Means earlier it was 5,000. The question to myself, can I contribute if I am an employer on anything over and above 5,000 or 6,500 or 15,000? Answer is very simple. A statutory scheme will prevail over everything. For information of us, many of the regional offices, I remember in Hyderabad, in early 1996, they asked the exempted establishment to contribute on the wages not exceeding rupees 5,000. We all are aware that in 1996, precisely notification number 134 dated 28th February 1996, possibly applicable from 16 March 1996, I remember, a proviso to para 11.3 was introduced in EPS 95 for pension on higher wages subject to RPFC permission or maybe APFC permission under para 26.6 of EPF scheme 1952. Till today, no form, no machinery provision have ever been provided by EPFO for signing an option or submitting an option under para 26.6. Now, here is a point to my mind. The concept of pension on higher wages was introduced in 1996. It was there in 1996, almost 30 years back from now. It is not the Honorable Supreme Court who has propounded the concept of pension on higher wages. It is there very much there in the rule book itself way back in 1996. What was the problem? Was there any problem regarding finance to be arranged for the purpose of higher pension during those days? And if it was there, why this provision was not stripped off from the rule book? But today it is being propagated how much amount will be required for meeting the obligation. Okay, I'll come to this point maybe in this video or separately in other video about financial deficit. Now we all know that this 5,000 rupees, when this came, there was no provision in the trust rule. I believe across the country there was no provision, any provision in the trust rule for contribution to pension fund either on ceiling wages or 5,000 rupees or on actual wages or whatever. But employer continued to pay 8.33% of wages limiting to 5,000 rupees. If your salary or wages is less than 5,000, it will be limited to that. And if it is more than 5,000, it will be limited to 5,000. 2001 notification 383 dated 24/05/2001. This ceiling wages was raised to 6,500. Immediately after that, 1st June 2001, ceiling was raised to 6,500. On 6 June 2001, a circular was issued by EPFO to all the RPFCs across the country to to make sure, to ensure strict compliance of ceiling wages of rupees 6,500 by the exempted establishments. Because for unexempted, it is in the hands of the government. Whatever they want to do, they will do. But for exempted establishment, they have to make sure that the compliances are made by exempted establishment as advised by the government. Now, even at this juncture, many of the exempted establishment did not have any provision in the trust rule to accommodate 6,500. But as I said, that employer is bound by, government rules and circulars, not by the trust rule. Then sometime in 2001, looking into the, different kind of provisions, they came out with a model provident fund rules, and they also circulated an official handbook on EPS 95 sometime in 2001. Many of us may be aware that Rule 11B and Safeguard Rule 31A is a beautiful language in that those paras is coming out of Model PF rule only. Even EPFO issued a circular dated 27th December 2007. I am repeating, 27th December 2007. If anybody doesn't have these circulars and whatever I am talking, they can contact me separately. I will provide them. It is written in that circular, I will read out, the model PF rule to serve as a guide to the employers in framing the PF rules of their establishment. They are themselves telling that you can use this model PF rule as a guide for your establishment in bringing the provisions in your trust rules. It is, however, not mandatory to adopt them verbatim. Where an employer decides to frame PF rules incorporating some greater benefits than those offered under EPF scheme 1952, the same shall be quite acceptable. Again, idea is that beneficial schemes are to be given to the employees and pensioners. We all know that as per para 27AA of EPF scheme 1952, condition number 11 possibly, the jurisdictional RPFC has to approve the trust rule. It is also written in that condition number 11 that suitable opportunity is to be given by RPFC to the employees and to the pensioners, mainly to the employees now, because pensioners, though they become pensioner only when almost they leave the organization. So opportunity is to be given to the employees to explain their point of view before approval of trust rule. I am very sure nowhere across the country any such opportunity have ever been given by the regional offices before approval of trust rule. Option and consent are totally lacking. I'll come to this again. We all know that pension on higher wages, the scheme, is only on the rule book. It has never seen the ground or the surface ever by the government of India. And I say so for a reason. Kindly see EPFO circulars dated 22nd June 2004, 1st December 2004, 22nd November 2006, 8th November 2013, and also few circulars in 2014. EPFO grossly and totally disinstated the contribution to pension fund on higher wages. My video will be very long if I start discussing on these circulars. I can provide the copy of this and many of us are aware of it. Point is that you have brought a scheme of pension on higher wages on paper, but on the ground by exercising the executive powers, you have discouraged the organizations and establishment to allow pension on higher wages or to contribute to pension fund on actual higher wages. We are aware that ceiling wages was revised to rupees 15,000 with effect from 1st September 2014. Notification number 609 dated 22nd August 2014. Many exempted establishments even did not amend trust rule till now, but they continued to contribute on revised ceiling wages of rupees 15,000 as statutory compliance under condition 10 of para 27AA of EPF scheme 1952. This is interesting. This has been confirmed to one of my friend on being asked through a RTI query also. What is condition 10 of para 27AA under appendix A of EPF scheme 1952? That any amendment to the scheme, I am repeating, any amendment to the scheme which is more beneficial to employees than the existing rules of the establishments shall be made applicable to them automatically pending formal amendment of rules of the trust. Again, idea is that if organizations are not acting or if government is not acting and if any beneficial scheme is coming up in between, then that should get applicable automatically, and that is what is R.C. Gupta and Sunil Kumar's judgment is all about. If a beneficial scheme is derived from the mandate of the apex court, it should get applicated automatically even without any formal amendment in the trust rule. Employers are responsible for contribution to pension fund as per EPS 95. Who is responsible to contribute in pension fund? Is it employee or employer? Obviously it is employer, not even the trust. It is the employer's duty, not the trust duty. Para 42D of EPS 95 is very specific that contravention of EPS 95 provisions, that is with regard to even payment to pension fund at the prescribed rate and amount, there can be an imprisonment up to 1 year or fine up to rupees 5,000 or both. Now, obviously, employer has to follow the EPS 95 and not the trust rule, because trust rule says 6,500 and employer is even till today contributing 15,000. So whether he will follow the trust rule or he will follow the EPS 95. And if he follows the trust rule and restrict the contribution to 6,500, then he has to face the imprisonment up to 1 year. That is what is 42D of para of EPS 95. We all are aware that series of compliance audit and regular inspections are being carried out by the inspectors of EPFO under section 13(1) of EPF Act. I am very sure trust rule have never been objected with regard to compliance to EPS 95 in last 30 years. So much so, when demand letters have been issued, that is after complete verification, not just like that. We are aware of para 16A of EPS 95, that is guaranteed pensionary benefits to the pensioners. None of the pensionary benefits under the scheme shall be denied to any member or beneficiary for want of compliance of a requirement by the employer under subparagraph 1 of paragraph 3, provided, however, that employer shall not be absolved of his liabilities under the scheme. Means employer has to follow EPS 95 and the directions, instructions issued thereunder from time to time verbatim. Otherwise he has to face the consequences. We all know post R.C. Gupta judgment, Specific approval has been given by Ministry of Labour and Employment on 16 March 2017 for pension on higher wages based on contribution of differential wages, that is actual wages minus ceiling wages, along with applicable interest for the purpose of entitlement to pension on higher wages. I am not reading out those words to avoid the time consumption here. Here also no reference to the internal trust rule at this stage was ever observed by EPFO. However, exempted establishments were disallowed. POHW, White Circular dated 31/5/2017. Still in 2017, Circular 31st May 2017 specifically, it was categorically stated in para 5 of that circular that Provident Fund is being managed by exempted establishment and pension fund and pension scheme is being managed by EPFO. Very clearly it was mentioned in that circular. Now Sunil Kumar judgment, I will come up separately about the legal scrutiny of the whole case, pension on higher wages. But Sunil Kumar judgment is a loaded judgment. We all are aware that higher pension has been allowed both for exempted and unexempted establishment with a direction to contribute differential amount and exercise of joint option within a window of 4 months. It was extended by EPFO from time to time then. And we are also aware that series of circulars and an online portal was provided for joint options. About 17.5 lakh people have applied. It is as per EPFO's declaration of the data. We are also aware that about 2.5 lakh or 2 lakh applications were rejected for certain reasons. We are also aware that about 4 lakh people have been considered for issue of demand letters and many have been given the pension on higher wages, leaving about 11 lakh applicant belonging to exempted category. We will come to that. A very loaded requirement of compliance of para 26(6). It has been relaxed substantially wide EPFO circular dated 14 June 2023, and it was told in that circular that even a copy of salary slip or a letter from employer or a wage detail submitted by the employer would be sufficient for compliance of para 26(6) for the first time. FAQ dated 13th December 2023 also was all about relaxing the requirement under para 26(6). It was further, one step further, stating that the RPFC will obtain any of the document as mentioned in the circular and no application for validation of option or joint option can be rejected only on this ground if otherwise eligible. It will be the duty of RPFC to make sure that any of the proofs as mentioned in the circular is obtained from the employer, that is salary slip, any letter or wage detail. In last 30 years of EPS 95, no option and consent were ever obtained except the joint option submitted by all of us post Sunil Kumar judgment. Surprisingly, unexempted and few selected exempted establishments were allowed POHW, leaving many of us on the lame excuses of trust rules. Now comes then what are the issues before? We know that trust rule limit contribution on pension fund on ceiling wages of rupees 6,500 as per 11B I will not repeat 11B, video will be lengthy. We have also been told in writing in the rejection letters that our cases are ineligible, relying the EPFO circular 18th January 2025. In many of the rejection letter, it has also been written that employees have opted for larger PF benefits over larger pension benefits. I don't know which kind of concept have been evolved beautifully by EPFO and their advisors and executives. Now here I would like to visit for a while the EPFO circular 18 January 2025. You know, it has 3 elements in it. I have here in my laptop, but I will not read through. That circular clarification number 2 has got specifically 3 elements in it. Pension on higher wages with respect to exempted establishments are to be verified and admitted based on extent trust rules. Number 2, in consonance with Sunil Kumar judgment. And third, a cut-off theory have again been evolved by EPFO top notches, telling that if there is any amendment post 4/11/2022, those will be simply rejected. That means you should have assumed and presumed that there is a need for amendment prior to 4/11, and why not you have done it. Now coming to one by one, according to extent trust rule, in this circular nowhere it is written that extent trust rule means only a part sentence in 11B, that is provided your selling your wages crosses, contribution crosses 6,500 rupees, then it will be limited to 6,500 only. This is the only para to be taken out, carved out. Whereas there are safeguard provisions 31A that has been totally bypassed. 18 January talks about extent trust rule. 18 January circular doesn't talk about contribution to limited to ceiling wages of 6,500 or safeguard provision. It talks about trust rule. How come in a beneficial scheme, in a social welfare scheme, somebody is taking out which is nothing but a mirror image and verbatim copy of model PF rules in consonance with Sunil Kumar judgment? I don't know how many times I have read through line by line, word by word Sunil Kumar judgment, and I try to understand from the experts in the country what is Sunil Kumar judgment all about as far as trust rule is concerned. I fail to, take out a single word or sentence about trust rules in the Sunil Kumar judgment, which restricts. Rather, Sunil Kumar judgment says that the organization and the employees and the members who have contributed on 6,500 are now eligible to exercise options along with their employers to contribute on the wages exceeding 6,500 and to pay differential contribution along with interest, and a window of 4 months have been given by Supreme Court, basing R.C. Gupta judgment wherein cut-off theory has been demolished. No mention of trust rule in Sunil Kumar judgment. Now cut-off theory 4/11/2022. After that, if I have amended my trust rules, I am not eligible. Arey Baba, you have already taken out a cut-off theory in your 26/6, 11/3 and 11/4 and 1/9/2014 and whatnot. Those all have been demolished, those cut-off theory, both in R.C. Gupta and Sunil Kumar judgment in 2016 and 2022. A new cut-off theory have been evolved by EPFO. to deprive us from higher pension. I was talking about condition 10 of para 27AA of EPS scheme regarding automatic application. Now, yes, if a beneficial theory has been evolved, giving a 4 months window, clearly directing, admitted by government also, 29th December 2022 circular, and thereafter about a dozen of circular. So this particular condition 10 of 27AA, para 27AA, gets activated automatically in favor of pensioners, those who are ready to contribute. Surprisingly, we from Bhilai, Chhattisgarh, when we asked EPFO whether internal trust rule will have overriding effect on EPF Act and schemes thereunder, they have given us in writing that it will not have overriding effect. They are themselves agreeing, but in the court they are telling no, it is your trust rule which will prevail on everything else, even the act and the scheme passed by the parliament. I am wondering, I tried to take out some of the instructions or circulars which has asked the employees to choose between PF benefits and pension benefit, maybe for suitable disclosure in the trust rule. But I doubt, and I am sure also, that no such circular has ever been issued by EPFO in this regard. If you go through EPS 95, it has got a very detailed provision as to how pension fund will be managed by the government of India. Pension fund account, pension fund disposal, pension fund audit, pension fund valuation, pension eligibility, pension calculation, pension entitlements, and distribution and disbursement of pension are completely and exclusively monitored by EPFO without any reference to PF trust rule. So what they are telling, that we will decide your pension throughout your life, we will be the person, but as far as contribution to pension fund is concerned, your trust rules will prevail, and that too the way they want. Because if my trust rule is still talks about 6,500 rupees ka selling wages, they will say no. Condition 10 of para 27AA is applicable in that case, and 15,000 will get applicated. Even they have issued a circular dated 23rd May 2023, wherein they have said that rejections are to be based on substantial and justifiable reasons. I am very sure reasons are neither substantial nor justifiable. These all are legal words. They should know how to use it. I was going through EPFO pension manual dated 15th November 2024. There is a chapter on higher pension on higher wages, nothing about internal trust rule in that. Exemptions are triggered and governed by exemption manual dated 9/11/2023. Specific chapters are there, possibly chapter 3. No stipulation about the applicability of internal trust rule for higher pension. One more interesting thing, that EPFO never prescribed a format for exercise of option under 26(6) for pension on higher wages, as I said earlier. Surprisingly, Ministry of Labour and Employment, via their letter dated 31st May 2023, also took a very serious note of this exercise of option under para 26(6), stating that it is the failure of EPFO, it is a total management of EPFO, mismanagement of EPFO, to devise a proper format for 26(6) and hence mounting applications for pension on higher wages post Sunil Kumar judgment. We all are aware that existing pre-revised pension or lower pension of 2000 rupees to 4000 rupees which we are getting are also based on ceiling wages as prescribed in EPS 95, not as prescribed in trust rule. Because many of us, even myself also, my last, applicable wages for the purpose of pension is 15,000 rupees, which is as per EPS 95. Whereas my trust rule is still have ceiling wages of rupees 6,500. So as far as my pre-revised pension is concerned, it is based on EPS 95. As far as my higher pension is concerned, it is as per ceiling wages in the trust rule. Different type of stories on different point in time. One more point, what exactly is happening in unexempted establishments and the establishments which are exempted but are in enjoyment of POHW, are they contributing on anything else other than the ceiling wages on as per EPS 95? And answer is very simple, that they are also contributing on ceiling wages and they are enjoying and they are eligible for higher pension as per the mandate of Apex Court in Sunil Kumar. I am not naming those organizations and exempted establishment who are in enjoyment of POHW at this moment. Now, the way I have, analyzed, and as it is said that two wrongs do not make a right. Basically, the self goal by EPFO. There are two things. One is that you have carved out select exempted establishments for the purpose of higher pension, and another self goal by EPFO, time will say, is stoppage of POHW to already granted POHW to the exempted establishments. It is very sorry to know and appreciate that many people have been granted pension on higher wages and subsequently those benefits have been withdrawn. The entire money paid was recovered back. Rejection without any opportunity of hearing to the employees and pensioners is against their own circular dated 23rd April 2023. Video is getting long, I know, but there is a need to know and understand these things. It is categorically written in para 9 of that circular 23rd April 2023 that if an application or joint option is not found eligible, then an opportunity shall be given to pensioners and members and employers to submit the requisite evidence details through the employers only. However, before any such rejection, an opportunity will be given to the employer for providing any additional proof or evidence or correct any mistake or errors, including those made by employees and pensioners. Such opportunity will be for the time period of 1 month and under intimation to the employees and pensioners. So grossly violating the law of natural justice. No such opportunity has ever been given to us, that is pensioners. Number of decisions support that rejection without authority of law is not correct. When I try to cover up the legal scrutiny, these all points will be covered. These rejections are basically an afterthought of EPFO to deny higher pension to all of us. We all know also that trust rule, exemption conditions are administrative circulars being subordinate instruments, cannot override, restrict, or curtail the benefits flowing from EPS 95. Without going into the details of the cases handled and decided and ordered by the Honorable High Courts, we may be aware there are as many as 9 orders available so far from different high courts across the country. Specifically, Madurai High Court dated 2nd September 2025, Kolkata High Court 14 November 2025, Telangana High Court 15 December 2025, Lucknow High Court 19 December 2025. Kolkata High Court has passed 3-4 more orders on separate dates without any reference to internal trust rule. My point is that they have considered that trust rule will not have any play or interplay as far as benefits arising out of EPS 95 concern. I will not go into the details of those cases. I will come to that separately. Interestingly, there is an internal legal opinion to EPFO headquarters dated 12th June 2023 by their advocate, Mr. Siddharth. I am reading 12th June 2023 legal opinion to EPFO headquarters by their own advocate. Kindly see para 10 to para 12 of that opinion. Due to paucity of time, I am not going into that. We all are aware that delay and denial of POHW is blatantly against the Article 14, 21, 141, 144 and 300A of the Constitution of India. We all are aware Article 14 equal protection of law in India, Article 21 rights to life and personal liberty, Article 141 Supreme Court is the ultimate authority on law, Article 144 all authorities in India should act in the aid of Supreme Court judgments, and Article 300A no person shall be deprived of his property save by authority of law, and it has been held by the courts that pension is a property. Now, before I conclude, I have only one thing to say, because it is already going to be some 50 minutes of this video, that by issuing the circular of 18th January 2025, the EPFO has committed an act of administrative overreach that undermines judicial authority. EPFO has attempted to reintroduce hurdles that the Supreme Court had already invalidated. EPFO has diminished the exempted status of the employer, which is a management privilege rather than an employee disability. EPFO has created a constitutionally impermissible divide between the classes of workers, though the Supreme Court categorically forbade in the judgment of Sunil Kumar. EPFO created an unreasonable classification and further subclassification between exempted and unexempted establishment. And lastly, EPFO has reintroduced a direct violation of right to equality under Article 14 of the Constitution of India. And hence, before I leave, I urge, expect, hope and pray that EPFO must avoid ego-driven mechanism prevalent in the organization, avoid wastage of public funds in litigation, and come forward to accept the mandate of apex courts and high courts and accept the higher pension applications of us, the pensioners. Thank you so very much. I will come separately on some other issues. Thank you so much.